Okay, so we're going to get started this morning. I'll just introduce myself. I'm Robin Wilson, formerly of the W&L faculty, more recently the University of Illinois. And it's my pleasure to moderate this panel. As we saw yesterday, it promises to be extremely balanced, and maybe there'll be some heat. I don't know. I've seen a few of these people in action before, so I suspect that there might be. And so we're going to start off with Caroline Corbin at the University of Miami, who's going to talk about abortion distortions. Teresa Collett will follow from the University of St. Thomas, who's going to talk about fetal pain and does it matter constitutionally. Kathy Greenier is doing double duty, not only as a speaker. She's from the ACLU of Virginia, and talk about targeted regulation of abortion providers and the war against women's health in Virginia, but we're especially grateful to the ACLU of Virginia for co-sponsoring the event. And finally, we'll have Randy Beck, who joins us from the University of Georgia, who's going to talk about overcoming barriers to the protection of viable fetuses. I know that we have a timekeeper who I'm sure will keep everybody on their game plan, and I'll be over here if you need some help. Thank you, Caroline.
So I don't have to lunge in the middle. So first, I'd like to thank everyone who made it possible for me to be here. I very much appreciate the invitation and all the organizing efforts that were made on my behalf. So thank you. My presentation focuses on the distortions that surround abortion jurisprudence. And I have in mind two types of distortions. First, there are distortions of science. Factual claims are made and accepted that are contrary to the weight of scientific evidence. And the second kind of distortion that occurs in abortion jurisprudence is that the normal doctrine does not apply. So, for example, First Amendment rules are suddenly different when a claim involves abortion. Such distortions not only harm women, but delegitimize First Amendment jurisprudence. So today I'm going to talk about two examples that exhibit both of these distortions. The first involves a claim that abortion regularly causes mental distress in women who have opted to terminate an unwanted pregnancy. In fact, no well-designed study establishes this. Nonetheless, this assertion has been used to justify a slew of laws requiring women seeking abortion to be provided with certain information lest they later suffer from post-abortion syndrome. So, for example, South Dakota requires doctors to tell women seeking abortion that they're about to terminate the life of a whole, separate, unique, living human being, and that the pregnant woman has an existing relationship with the unborn human being. Doctors have challenged this regulation as violating their right against compelled speech, but the Eighth Circuit Court of Appeals rejected their claim. So starting with the scientific distortion, abortion does not, in fact, undermine women's mental health. There is no post-abortion syndrome. Abortion does not increase women's risk of depression or suicide. This conclusion is not based on my own analysis, but on numerous review of the empirical research by respected mainstream medical and scientific groups. So here's a sampling. The American Psychological Association concluded the best scientific evidence published indicates that among adult women who have an unplanned pregnancy, the relative risk of mental health problems is no greater if they have a single elective first trimester abortion than if they deliver that pregnancy. Scientists at Johns Hopkins concluded a clear trend emerges from this systemic review. The highest quality studies had findings that were mostly neutral, suggesting few, if any, differences between women who had abortions and the respective comparison groups in terms of mental health effects. A group of doctors wrote in the Harvard Journal of Psychiatry, the most well-controlled studies continue to demonstrate that there is no convincing evidence that induced abortion of an unwanted pregnancy is per se a significant risk factor for psychiatric illness. In their study for the UK Academy of Medical Royal Colleges, the National Collaborating Centre for Mental Health and the Royal College of Psychiatrists concluded that the best available evidence shows rates of mental health problems for women with unwanted pregnancy were the same whether they had an abortion or gave birth. Studies that show otherwise suffer from serious methodological flaws. One of the most common is the failure to include an appropriate comparison group. That is, several studies compare women with unwanted pregnancies who terminate to women with wanted pregnancies who carry to term. Comparing women with unwanted pregnancies to women with wanted pregnancies is a bit like comparing apples to oranges. It makes it impossible to discern whether post-abortion outcomes are due to the abortion or to the unintended pregnancy. Another common flaw is failure to control for other co-occurring or confounding variables, such as prior mental health or exposure to violence. Again, without controlling for these, it makes it impossible to conclude that post-abortion outcomes are due to the abortion as opposed to the other factors. Indeed, the best single indicator of mental health problems after abortion is mental health problems before abortion. While this mandatory abortion counseling law itself is grounded in distorted science, the court's analysis of the challenge to the law fails to apply the appropriate First Amendment doctrine. This is the doctrinal distortion associated with mandatory abortion counseling. So a couple of free speech basics might help explain. Right? One, free speech law protects the right to not speak as well as the right to speak. And two, government attempts to impose an orthodoxy is anathema in free speech. That is, government is considered to have violated the freedom of conscience free speech is designed to protect when it either censors viewpoints it disagrees with or compels the recitation of viewpoints it approves. So while the government may have the right to speak on its own behalf and state that it prefers childbirth over abortion because it considers abortion akin to murder, the state cannot silence you if you disagree or force you to parrot its point of view on such a contested issue. As a result, in free speech law, when the government tries to either censor or compel expression of a particular ideological viewpoint, such regulation is presumed unconstitutional and at the very least is subject to strict scrutiny. Despite this backdrop, the Eighth Circuit did not apply strict scrutiny to doctors' free speech claims against the requirement that they convey the government's viewpoint on abortion and tell women that they were about to terminate the life of a whole, separate, unique, living human being. Instead, the Eighth Circuit applied the Casey undue burden test from substantive due process and called it a day. That is, they held that just as it does not violate women's right to abortion to be told accurate and non-misleading information, it held it does not violate doctors' free speech rights against compelled speech if it passes the same test. Thus, these doctors' free speech claims have been treated differently than just about every other free speech claim. Now, are there reasons to treat doctors' rights against compelled speech differently than others' rights against compelled speech? Well, some have argued that informed consent requirements are simply the regulation of medicine and therefore are really more regulation of conduct than speech. And there is language in Casey along these lines, though that language is both open to interpretation and free speech pushback. But even accepting this characterization, in order for this state-mandated script to be considered regulation of medicine, it has to actually comport with professional medical practice. Forcing doctors to tell their patients that their unwanted pregnancy is a whole, separate, unique, living human being is not medicine, but ideology. Real informed consent, where patients learn about their proposed procedure and its alternatives, is neutral as to the patient's decision. Mandatory abortion counseling, on the other hand, attempts to persuade the patients to choose one option over another in contravention of professional medical ethics. Conveying the government's moral stance on abortion is simply not part of the ethical medical practice. In short, contrary to fundamental free speech values, in this one instance, and this one instance only, the government is permitted to force doctors to fall into line with state orthodoxy regarding abortion. My second example, illustrating this dual scientific and doctrinal distortion, involves morning-after pills like Plan B and the contraceptive mandate. As you probably all know, the new health care law requires large for-profit corporations to provide health insurance to their employees, and that health insurance must include morning-after pills like Plan B. Several employers have objected on the ground that these bills are abortifacients. Their religion condemns abortion, and forcing them to include these pills in their company's health care plans violate their corporations and their own religious rights. But here's the rub, or should I say, here's the scientific distortion. Morning-after pills are not abortifacients. An abortifacient ends a pregnancy. These drugs do not end a pregnancy. So again, some basic biology might help understand. Many people erroneously assume that pregnancy occurs immediately after sexual intercourse, and therefore any measure taken after sex works to end a pregnancy. In fact, that's not how our bodies work. While an egg survives for only about a day after ovulation, sperm can live for up to 5 days. Consequently, the woman can ovulate and release an egg up to 5 days after sex and eventually become pregnant. Plan B and Ella are contraception because they prevent women from ovulating. That is, they prevent pregnancy by preventing a release of an egg in the first instance. Now, while some people have speculated on how these pills work, every reputable study to examine Plan B's mechanism has concluded that these pills impede ovulation. In fact, if you take Plan B after ovulation, they're ineffective. That is, studies show that women who take Plan B pills after ovulation become pregnant at the same rates as women who take nothing at all. So Plan B inhibits the pre-ovulation luteinizing hormone surge, without which ovulation does not occur. No LH surge, no release of an egg. Ella is a bit more effective because, unlike Plan B, it can prevent or postpone ovulation even after the start of the LH surge. Courts cannot and should not question plaintiffs' religious beliefs. The courts can and should question the accuracy of their science. Plaintiffs' opposition in this example is based on a medical mistake. They are religiously opposed to killing fertilized eggs. Neither Plan B nor Ella kills fertilized eggs. Plaintiffs' claims regarding the morning after pills really should have been rejected. To paraphrase Daniel Patrick Moynihan, everyone is entitled to his religious beliefs, but not to his own facts. The First Amendment distortion in this line of cases is not as obvious as in the first example, where it seems like the courts have simply failed to apply free speech doctrine. Instead, the distortion here is that courts seem willing to stretch free exercise doctrine in novel ways, not really supported by the current jurisprudence, in part because of the abortion and reproductive rights context. That is, I suspect they are accepting free exercise claims that would have been rejected in a different context. For example, the claim that for-profit corporations have religious liberty rights. Whether for-profit corporations are rights holders under the Free Exercise Clause is a question of first impression. Existing jurisprudence suggests not. Nonetheless, courts ruling on the contraception mandate challenges have been divided in their answer. The point I want to make now is not that for-profit corporations are not entitled to religious exemptions, although they really aren't. I don't have time, though. Rather, the more narrow point I want to make is that courts are much more willing to accept this proposition when made in the abortion reproductive rights context. So consider this counterfactual. So imagine a multi-million-dollar family-owned corporation that employs thousands of people. It sells arts and crafts supplies in stores across the country. The family is quite devout. They have very strong religious beliefs against killing or harming of animals in any way. A new federal law mandates that companies with over 50 full-time employees provide comprehensive health insurance. Thanks to this requirement, employees may receive, without cost sharing, preventive medicine including diabetes medication and cholesterol-lowering drugs. The owners, however, object to including these drugs in the company's health insurance plan because they believe they might be made with animal byproducts. They are mistaken, as a brief written by the American Medical Association and the American Heart Association point out. In fact, there is no clash between the law and their deeply held religious beliefs. Nonetheless, the company sues, arguing that it violates their corporation's religious liberty rights to provide these medicines and that they're entitled to be exempt from the requirement that they provide them. Do they win? Now, I could be wrong, but I suspect the courts would not be as receptive to these claims as some have been to the contraception mandate ones. In other words, it's probably not an accident that the idea of corporate religious liberty has presented itself in the context of women's reproductive rights, an area where courts regularly bend the rules. The bottom line is, these distortions are bad for science, bad for women, bad for the court's integrity, and bad for the First Amendment. Thank you.
First, I want to apologize for being late, and second, to thank the organizers of this conference. It really is unique. I have participated in a number of conferences related to abortion, and invariably been one of 12 that is pro-life, and the other 11 object to my position. So it is a welcome change to actually have a 50-50 split in presentation, because the American Academy doesn't do this very often. So thank you very much. The topic I want to talk about is related to a case that is currently before the Supreme Court on a cert petition, which is Isaacson v. Horn. But I don't want to talk about Isaacson v. Horn in specific. I want to talk about the premise that fetal pain could be an independent state interest that would allow regulations in abortion cases, at least at 20 weeks or beyond. So let me present the case for pre-abortion, pre-viability abortion bans, I think. Those of you who follow this area, all of our speakers at least, know that currently there have been efforts to bar abortions at 6, 12, and 20 weeks. The courts have intervened in North Dakota, Arkansas, and Idaho. An appellate court struck down Arizona's 20-week ban. That's the Isaacson v. Horn case that's currently on petition to the Supreme Court. And laws imposing restriction on doctors in North Dakota and in Idaho have also been enjoined. Whoops. Why 6 weeks? This is the most aggressive statute. It's out of Arkansas. And the legislative history reflects that it is what's called a heartbeat bill. Now, the prior speaker talked about bad science. This isn't a case of bad science. There's really no debate about whether or not the fetal heartbeat is in existence at 6 weeks. In fact, it's fairly late. The fetal heartbeat begins on the 22nd day of development. And by the 5th week of pregnancy, you can actually see this. The chart comes from a peer-reviewed medical journal. The 4 cases that these things arise in are Edwards v. Beck, Isaacson v. Horn, McCormick versus Heidman, and MKB Management Corporation. Whoops, I'm not doing this right. Okay, so let's jump ahead to 20 weeks, which is the Isaacson case. North Dakota joined Nebraska, Kansas, Idaho, Oklahoma, Louisiana, Georgia, Alabama, Texas, and Arkansas in enacting laws that say that abortions cannot occur at 20 weeks because there is compelling medical evidence that pain occurs. That's part of the debate. Whoops. It's an old debate. 30 years ago, President Reagan, in a speech, noted that when the lives of the unborn are snuffed out by abortion, they often feel pain that is long and agonizing. The speech was in response to viewing a movie called The Silent Scream, a movie produced by a physician who was, at least initially, active in performing abortions, but came to believe that, like the Eighth Circuit has held, in the South Dakota case, the Rounds versus Planned Parenthood case, abortion ends a unique, separate life of a human being. So President Reagan caused somewhat of a national debate on this issue by his public statement. It died off until 1999. And in 1999, we saw another incursion into this area where the top picture was presented to the world based on a surgeon that it appears a tiny hand is grasping from the womb. The baby involved is Samuel Armas. You can see him as he developed through his early childhood. Samuel Armas had spina bifida. One of the great advances of contemporary obstetrical science is that now, with certain illnesses and diseases and conditions, we can actually intervene in the womb. It's called perinatal surgery. And we can repair the spine so that a child that otherwise would have been crippled and suffer throughout his lifetime will be born, and that will heal, and he will be an active adult. Another area which we can do this in is with hydrocephaly, a disease that causes the brain not to develop because of fluids. We can enter the womb, put a shunt that fluid off the brain, and the child will grow up to be a healthy human being. It's a great miracle of modern science. Well, the surgery was being performed on Samuel Armas, and the little hand came out of the womb, wrapped itself around the surgeon's finger. At least that's what some of those present say occurred. And the shot made the front page of Life magazine, made the cover of Life. That caused people to stop and think about, what does a child at that stage look like? And what was the debate about the surgery? In this case, what the claim is in Isaacson v. Horn is that at 20 weeks, the unborn child has sufficient physiological development to actually experience pain through the abortion process. Now, we know that the court has recognized the state's capacity to ban abortions at 23 to 24 weeks. That was the stage set in the Webster opinion. In Roe, it told us that post-viability abortions can be regulated, subject to the Doe v. Bolton exception, because the fetus then presumably has the capability of meaningful life outside the mother's womb. State regulation protective of fetal life after viability thus has both logical and biological justifications. If the state is interested in protecting fetal life after viability, it may go so far as to prescribe abortion during that period, except when necessary to preserve the life or health of the mother. Now, I won't repeat Clark Forsythe's presentation from yesterday, but how they drew that line is unclear in the historical record, and whether or not it actually has adequate logical justification. But nonetheless, we know that very few abortions occur post-viability. The latest statistics we have from the Center of Disease Control tells us that 1.3% of the 1.2 million abortions in 2009 occurred at 21 weeks past. That means that the case I'm talking about, if the law was upheld, would affect approximately 180,000 abortions a year. 180,000 abortions a year. Now, that's not a huge number when we're thinking about an industry that performs the procedure anywhere from the range of 1.2 million to 1.3 million. But 180,000 people are a lot of people. All right? So some people in the pro-life movement question, why are we expending all the political capital and effort we are on this topic for a mere 1.3%? Okay, I understand the percentage argument, but it's 180,000 people. That's a lot of people. So we know that post-viability abortions occur. We know they're constitutional. The question is, are pre-viability bans constitutional. And in Gonzalez versus Carhart, the court upheld the federal partial birth abortion ban that made no distinction based on viability. The court said the act does apply both pre-viability and post-viability because by common understanding and scientific terminology, a fetus is a living organism while within the womb, whether or not it is viable outside the womb. Again, responding to Caroline's presentation. Granted, we're not entitled to our own scientific facts, but the Eighth Circuit en banc ruled on the question of whether abortion ends a unique, separate life of a human being and said plaintiffs have presented no evidence, again, no evidence that abortion does not end a unique, separate life of a human being. So, fair enough. We're not entitled to our own facts, but we are entitled to the facts. Abortion ends a unique, separate life of a human being. Whether or not fetal pain is of constitutional concern is something that has been presented to the court at least collaterally in prior cases, and even former Supreme Court Justice Stevens acknowledged that fetal pain has some relevance. He continually voted to strike down at state abortion regulations, but in listing state interests that should have some constitutional consideration, he stated the organism's capacity to feel pain was a basis upon which the state's interest in the protection of the embryo increases progressively and dramatically. Again, we're talking about 20-week bans. There is some debate about whether the unborn child at 20 weeks can experience pain. But that debate does not foreclose legislative action, again, as the court instructed us in Gonzalez versus Carhart. Medical uncertainty does not foreclose the exercise of legislative power in the abortion context any more than it does in any other context. So legislatures are free to make policy determinations even in areas where the facts are disputed. What are the facts that are in dispute? The facts that are in dispute is whether or not the unborn at 20 weeks feel pain. And that turns in part on how we define pain. Now, I'm acutely aware that we have a philosopher in the room, so he will appreciate some of the distinction here. But there are three competing definitions or ways of establishing pain. Those who object to abortion bans at 20 weeks, something that is uniform throughout Western Europe, those who object often object on the basis that at 20 weeks gestational age, the fetus simply is incapable of a conscious appreciation that it's experiencing pain. The fetus does not have, at least we can't prove, it has a concept of, I am hurting. And they say that is the ultimate definition of pain. That pain essentially doesn't exist unless we have a conscious appreciation of it. Now in June, I had a hip replacement. I have no conscious appreciation of pain during the surgery because, thanks be to God, they gave me good drugs. All right? But my body reacted to the invasion of the scalpel, the pulling apart of my hip, the removal of a piece, and the insertion of another piece. Clearly, there were physiological indicators that my body was experiencing trauma, which comes to the next two possible sources of evidence and claims. One is behavioral and physiological responses. When a human being withdraws from what's called a noxious stimuli, we usually count that as some evidence that there is pain experienced. Certainly, when we are considering whether animals are in pain, we look at that indicator as well. So the behavioral and physiological responses provide support for the concept that the unborn at 20 weeks experiences pain. The third element that is debated or contested is whether or not all of the neurological development is in place at 20 weeks for pain to be experienced. In other words, the human organism at that point simply, according to those who would strike down these bans, doesn't have all the equipment to experience pain. It simply doesn't have all the physiological pieces. So let's look at these arguments. Physiological evidence, behavioral indicators, and consciousness and self-report. The neurological development of the unborn child is something that begins very early with the development of nociceptors. That's the network of tiny pain receptors throughout your body. And interestingly, it starts with your mouth and develops throughout the entire body. It's a network, if you would. The students probably are more familiar with the neural network when you think about sort of the computer scan, the net that covers us, so that when we touch something that's hot or sharp, it's what creates the sensation of this is pain and carries it through the body. Behavioral indicators exist because we know that we use anesthesia for fetal interventions. In other words, doctors now for this perinatal surgery use anesthesia because it speeds healing and it causes the child to recover more. Consciousness is evidenced by the growing body of literature that shows that children are aware of what happened to them in the womb. This example, of course, is the listening to music. There are numerous reports that children recognize voices and music from during gestation. All of these pieces of evidence can be put together in a way that shows that the unborn at 20 weeks experience pain and that pain has long-term effects. Given that, doesn't the state have an interest in saying that abortion, while available through the first 19 weeks, should not be available at 20 weeks unless there is some sort of compelling need? The statute in Isaacson v. Horn includes an exception for the life of the mother, as well as for any substantial impairment of a major bodily function. The debate in this case is whether or not the pain of the fetus counts. It seems to me that this case, just like the partial birth abortion case, is as much about who we are as a people and whether or not we care more about puppies than we do about the next generation as it is about the medical evidence. No other Western nation would tolerate abortion on demand at 20 weeks. But the debate in this country has become so polarized and isolated that we can't even reach the common ground that the professor gave us yesterday, that at least after 20 weeks, there ought to be a dang good reason. Thank you.
Good morning, everyone. Thank you so much for having me here. I'd like to give credit also to the co-author of my paper for this symposium. That is Rebecca Glenberg, who is the legal director at my organization, the ACLU of Virginia. So as director of our Reproductive Freedom Project, I mostly handle policy, communications, and community organizing work, and Rebecca handles our litigation and legal issues with our legal team, and we're excited to be working together on this paper. So I will present a summary of the issues that we tackled in that paper, including touching on the legal flaws in the Virginia regulatory process to place new rules for women's health care centers, and hopefully do justice to her part of that paper. So let's start with a little bit of background. What are targeted regulations of abortion provider TRAP, is the acronym, laws. So TRAP laws require abortion providers to follow more stringent regulations than other similar outpatient medical facilities or doctor's offices providing in-office procedures. In Virginia, TRAP goes further than what we've seen in other states and requires that abortion providers meet hospital-style physical plant standards. As a result of these regulations, which generally cannot be met by doctor's offices or outpatient clinics, and which go far beyond the recommendations of recognized medical guidelines, TRAP laws limit women's access to abortions in usually one of two ways: by either forcing some centers to close because they cannot meet those new regulations, or by driving up the cost of abortion procedures so much that some women can no longer afford them, of course, because of the cost that the abortion providers faced when meeting these new standards. So next I'd like to discuss, for particularly in Virginia, but across the board as well, why hospital-style architectural standards are unnecessary and unrelated to the health and safety of patients. So first, some discussion of the safety of abortion. A routine first trimester surgical abortion takes approximately 5 to 15 minutes to complete. It's one of the safest types of medical procedures. I should note, in case folks are unfamiliar, it is first trimester abortion providers that are being regulated in Virginia with the imposition of these new rules. Complication rates occur in less than 0.5% of all procedures. Abortion care entails 1/1000th the risk of death involved in an appendectomy, which is a common in-office surgical procedure. And the complication rate from abortion is vastly lower than that of breast augmentation. It's another commonly performed in-office procedure. And I think the Guttmacher Institute summarized the statistics on the safety of abortion care in clinics and doctors' offices best in this way. Research from the CDC on abortions performed between 1974 and 77 found no difference in the risk of death between procedures performed in a hospital and those performed in a clinic or a physician's office. More recent studies have also found low complication rates for abortions performed in outpatient settings. According to ACOG, the American College of Obstetricians and Gynecologists, providing abortion in the context of private practice is entirely appropriate as long as physicians who do so in their offices are equipped to handle any emergencies that arise. In 2008, 18,000 abortions were provided in physicians' offices in the United States. And beyond the United States, this question has arisen as well. The World Health Organization has made clear that abortions can safely be performed not only in outpatient clinics, but also in physicians' offices. So next I'd like to talk about TRAP across the country and specifically in Virginia, how we got here. TRAP is now the law of the land in over half the states in the country, and it's certainly no accident from my perspective that TRAP and other measures that are aimed at curtailing access to abortion sweep the nation in this way. These measures are part of a coordinated, state-based, nationwide strategy. TRAP took center stage in Virginia, starting with the passage of Senate Bill 924 in 2011. At that time, we saw 9 such bills related to curtailing access to abortion, and that was at the start of the peak of abortion restriction measures in state legislatures. 2012 reached a record high in Virginia with 13 such measures. So prior to 2011, the Virginia General Assembly, the GA, did also consider TRAP legislation. It always ultimately failed, and proponents of the measure thus tried a different tack in 2011. The bill in the 2011 GA session started as an innocuous bill related to infection prevention, disaster preparedness for hospitals, nursing homes, certified nursing facilities in the state. The House added an amendment approved by a tie vote in the Senate, the tie broken by the Lieutenant Governor, then signed by the Governor, and it directed the Board of Health to promulgate regulations for abortion providers, placing abortion providers as a category of hospital that is a category subject to regulation by the Board of Health, but included no language about what those regulations should look like. Left it up to the board's discretion as they have discretion to regulate the other entities in that category. So the law directed the board to first craft temporary emergency regulations despite no actual emergency, and then final permanent rules. Just to clear up any confusion, it's actually the Virginia Department of Health, not the Board of Health, that first crafts the rules. And when they began drafting those temporary emergency regulations, they convened a medical committee comprised of OBGYN department chairs from hospitals around the state, folks who personally are pro-life and pro-choice. And after considering the regulations implemented in other states, materials from ACOG, the CDC, the WHO, and other public health organizations, that medical committee crafted the draft regulations with the Department of Health. The committee's recommendation stipulated that stringent physical plant requirements would not apply to existing health centers. But the Department of Health ended up releasing, and the Board of Health eventually approved, temporary regulations that impose construction requirements that are meant for new hospital construction onto existing women's health care centers. So a little bit more about those physical plant requirements. The regulations for Virginia's abortion providers require that within 2 years of the date of clinic's initial licensure under this new regulatory scheme, the existing women's health centers must come into compliance with 3 chapters of a manual called the 2010 Guidelines for Design and Construction of Healthcare Facilities. I'll just call that the guidelines. The guidelines are written, however, to apply exclusively to new hospital construction. They say so in the manual itself, and not to existing facilities, except in cases of significant renovation or additions, and then the guidelines apply to just that portion that's being renovated or added. And there is no other instance, I think it's very important to note, in which Virginia has required an existing health care facility to comply with regulations or guidelines designed for new construction. The architectural requirements included in this manual that abortion providers in Virginia must now meet include separate rooms for telecommunications and computer equipment, drinking fountains in waiting rooms, 6-inch handles on all sinks, larger procedure rooms, larger hallways, hospital-style heating, cooling, and ventilation systems, covered entryways. These are things that are beyond what is necessary to ensure patient safety. The Virginia Department of Health estimates that the total cost for women's healthcare centers across the state to make these physical plant changes comes close to $15 million. An average cost of $700,000 to around $969,000 per site. So with those temporary regulations in effect starting January 1st, 2012, the Board of Health considered permanent regulations exactly the same as the temporary ones, settling on regulations that became final on June 20th, 2013. And in the meantime, between that process, on June 15th, 2012, the board at first voted to amend a key provision of the permanent regulations. It approved an amendment to grandfather in existing women's healthcare centers rather than subject them to these onerous and unnecessary physical plant standards. The Attorney General refused to certify that regulation, and the board eventually adopted final regulations without a grandfathering in provision. Over the course of that rulemaking process, the Virginia's medical community continued to reject those regulations. So I'm going to close by talking about legal flaws in the regulation. The key legal question that arose during the regulatory process is whether the Board of Health has the statutory authority to adopt regulations that grandfather in existing facilities. In our paper, we assert the board has that authority, and that trap in Virginia resulted from a deeply flawed administrative process. I have time in these remarks to discuss the code relating to the board's authority, but hint, hint, you can ask me questions about the other flaws in the administrative process. So Virginia Code, it's 32.1, 127A, if you're interested, directs the board's statutory authority. That law directs the board to create regulations for healthcare facilities that are, quote, in substantial conformity to the standards of health, hygiene, sanitation, construction, and safety as established and recognized by medical and healthcare professionals and by specialists in matters of public health and safety. So, as I mentioned, the specialists who authored those guidelines themselves stated that the guidelines are intended to only apply to new construction, not to existing facilities. And, as I mentioned, imposing requirements meant only for new construction onto existing facilities is contradicting what medical and health professionals and specialists actually recommended in Virginia. So in that way, we argue that the board was most definitely within their authority to pass a regulation, including a grandfather provision. At the June 15th Board of Health meeting, the Attorney General's representative actually admitted that the guidelines are intended only in that way, that these standards have never been applied to existing facilities, and they acknowledged that the contratextual interpretation of the board's statutory authority would actually require that all of the regulations of all of the kinds of healthcare facilities in Virginia would need to be rewritten. Another crucial legal question is whether the board's inclusion of grandfather provision conflicts with another part of Virginia Code, 32.1-127.001. The Attorney General asserted that the grandfather provision is in conflict with that code section because that code section states that the Board of Health shall issue regulations for healthcare facilities that, quote, include minimum standards for the design and construction of hospitals consistent with the current edition of the guidelines. The AG's office, we argue, though, is incorrect about the board's obligations under that code. That section of the code, enacted in 2005, as I said, has never been interpreted to require existing facilities to meet new construction standards, and guidance issued by the Department of Health in 2006 after the passage of that law, when hospitals, nursing homes, and outpatient surgical facility regulations were amended to include reference to the guidelines per that new code section, makes it absolutely clear that those facilities were only to follow the guidelines when they engaged in new construction or alteration. So while that code section states that the board shall issue regulations consistent with the guidelines, because the guidelines explicitly state that they're intended only for new construction, the board's refusal to apply the guidelines to existing facilities is then consistent with the guidelines. I'll close by mentioning the effect that we've seen on women's health care centers and patients in Virginia. Already we've seen one clinic, Hillcrest Clinic in Norfolk, Virginia, close, citing TRAP and the expense of an estimated $500,000 to that clinic to stay open. And others may close when we reach the critical 2 years from the date of initial licensure point. And we expect that the impact will be felt most by rural women, young women, and communities of color already lacking access to health care providers. Thank you.
Good morning. Thank you to the W&L Law Review, to Dean Calhoun, to Laura and Thomas, and everybody who made this such a great conference, and the hospitality you've shown. Thank you also to the participants, and it's nice to be on a panel with some genuinely warm individuals. My paper is focusing on the part of the Roe decision that concluded a state has a compelling interest in protecting fetal life once it is viable, meaning that it's possible for it to survive outside the mother's womb with medical assistance. The viability line was the only part of Roe's trimester framework that the plurality opinion in Casey purported to retain. My earlier writing has generally been critical of the court's decision to peg viability as the earliest point in pregnancy at which a state can try to protect the life of a fetus subject to abortion. Here I highlight some what I think are justifiable criticisms of the viability rule. First, that the court's never offered a plausible constitutional or moral explanation for why it would draw the line at that point in pregnancy. Second, that viability seems like a random line to draw from a moral perspective. The viability of a particular fetus is influenced by a host of factors that seem to be irrelevant to the question of whether that fetus should be amenable to protection by the state. including the progress and availability of neonatal medical facilities, the race and gender of the fetus. African-American fetuses, female fetuses tend to become viable earlier in pregnancy than male or Caucasian fetuses do. Behavioral and environmental factors like whether the mother smokes during pregnancy, whether she's living in the mountains of Colorado or on the coast of California, all of those are factors that can affect fetal viability and seem to be irrelevant to the question of whether the state should be able to protect that particular human life. Third, that viability is an extreme line by international standards. Of those countries that, like the United States, say you can have an abortion for any reason you want, most of them, the vast majority, say that lasts for 12 weeks. Viability puts that out to about 24 weeks, so nearly twice as long. And finally, by drawing the line at viability, the court has set up a long-running mismatch between constitutional law and public opinion. If you look at Gallup polls going back for decades, you will find 65 to 70% of the American public who will say they think abortion should generally be illegal in the second trimester. The viability rule means that most of those second trimester abortions cannot be subject to substantial regulation by the state. If you want a reason why we're still talking about Roe 40 years after the decision, that would be my candidate for one of the reasons. Right? Now, for this paper, though, I wanted to concede for the sake of argument that viability is a morally and a constitutionally significant line, and that the state has a compelling interest in protecting the life of that fetus, at least at that point when it's viable. Are there obstacles that make it hard for the state to protect the lives of viable fetuses? The first that I identify concerns the difficulty of enforcing viability as a regulatory line. The court acknowledged the uncertainty of viability in a case called Collett versus Franklin. Basically, a physician trying to decide whether a fetus is viable considers a variety of factors: fetal weight, gestational age, health and nutrition, available medical facilities, etc. The result, the court says, it's not unlikely that experts will disagree over whether a particular fetus in the second trimester has advanced to the stage of viability. Interestingly, the court acknowledged that doctors might agree on the scientific question of what is the probability of survival of a particular fetus, and yet disagree on whether it should be labeled as viable or not viable. Right? Now, that creates some problems if a state is trying to enforce a ban on post-viability abortions. First of all, what about a doctor who simply makes a mistake about viability? What if a doctor concludes that a particular fetus is not viable when in reality that fetus could survive if you gave it proper medical attention? And second, what about situations where a doctor has an incentive to find a fetus not viable and therefore would be able to perform an abortion? Doctors who perform abortions for a living could have a conflict of interest in deciding on the viability of a particular fetus. If the state really has a compelling interest in protecting viable fetuses, you would expect the court to recognize some means by which the states could protect a fetus that was mistakenly labeled as non-viable. But in fact, what you find in the cases following Roe is exactly the opposite, that the court seems to require deference to the doctor's determination of viability, even if it might be a decision that other doctors would disagree with. In Danforth and Collett, the court emphasized that viability is a matter for the judgment of the responsible attending physician. Now, it's not complete autonomy. There is some recognition in those opinions that, if there's an abuse of medical discretion, you might have some way of addressing a mistaken determination that a fetus is not viable. But largely, you're supposed to defer to the doctor performing the abortion. I was trying to think of an analogy that would help illustrate the enforcement difficulties with viability, but take it outside of the politically fraught context of abortion. This is probably a mistake. I'm going to regret this. The analogy is not perfect, but maybe it will help get the point across. Imagine that the court found a fundamental right to drive. In America, that could happen, I think, right? And it says that the state has to have a compelling interest to regulate driving. They acknowledge that the state has a compelling interest in banning dangerous driving. They've got evidence from studies suggesting that in many trips, 90 miles per hour or above is going to be dangerous. But the court says you can't draw a numerical line, right? You can't just regulate 90 mile per hour driving. Also, the court says you have to defer to the driver's conclusion that he is not driving dangerously unless there's some abuse of discretion. and add into the mix the fact that some drivers might have personal or financial reasons to drive quickly, probably the result is you're going to have some dangerous driving that the state can't do anything about because of the rules of engagement set by the court. Now, a second obstacle to state protection of viable fetuses arises because most abortions in this country take place in private facilities. In Doe versus Bolton and the Akron decision, the Supreme Court rejected laws requiring hospitalization for abortions, either for all pregnancies or during the second trimester. As a result of those decisions and other factors, the Guttmacher Institute reports that nearly all U.S. abortions take place in non-hospital settings. So the information that is relevant to the enforcement question, are abortions being performed on post-viable fetuses, is gathered and maintained in a location that is isolated from the larger medical community. The difficulties that this creates, I think, are illustrated by the trial earlier this year of Dr. Kermit Gosnell. He is the Philadelphia abortion provider who was prosecuted earlier this year. His kind of competitive advantage in the marketplace, according to the grand jury, is that he was known as the doctor who would perform abortions at any stage without regard for legal limits. The trial jury eventually convicted Gosnell of first-degree murder for 3 infants that were born in his clinic, and then he cut the spinal cord after they were born, involuntary manslaughter of an adult patient who died after an abortion, and 21 counts of performing abortions after 24 weeks of pregnancy, in addition to numerous other counts. The grand jury did an extensive investigation. They concluded that Gosnell, we are convinced, committed hundreds of acts of infanticide. He got away with them for decades because they all took place inside his clinic. There were a number of steps that Gosnell took to try and avoid detection of his post-viability abortions. I won't go through them all in detail, but basically he submitted false reports to the state, vastly undercounting the number of second and third trimester abortions he was performing. He doctored the records to make it look like he was not doing post-viability abortions. He did the latest abortions on Sundays with nobody in the clinic other than his wife and the patient, so that people wouldn't see at least the most troubling cases. And he kept many of the files at home, destroyed a number of them so that they were not available when law enforcement personnel were trying to find out what he'd been doing. Now, one possible solution to the problem presented by the Dr. Gosnells is oversight by state officials. Unfortunately, in the Gosnell situation, there were at least 3 public health agencies that were informed about some of the problems at Gosnell's clinic, but failed to step in. The Pennsylvania Department of Health decided to stop performing inspections of abortion clinics in 1993. The concern was that some of the clinics wouldn't meet the state requirements, and as a result, inspections would hinder access to abortion. In theory, the department was supposed to do inspections when there were reports that raised red flags. However, the health department failed to inspect Gosnell's clinic for over 16 years, even though 2 patients died after abortions in that period of time. And there were several other problems reported to them. Similarly, the state Board of Medicine that does licensing of doctors didn't intervene, even though one of Gosnell's employees came and told them that his clinic was filthy, that he was having unlicensed workers administering anesthesia. They nevertheless let him keep practicing and did not intervene. And then third, the Philadelphia Department of Health. Gosnell was dropped from a vaccine program that they ran after an employee visited the clinic. She reported that it wasn't clean at all, that it smelled like urine. She reported that vaccines were being stored in a freezer alongside the remains of aborted fetuses. They terminated him from the vaccine program, but didn't take any other steps to address the problems going on at the clinic. So I highlighted 3 barriers that make it difficult for a state that wants to forbid post-viability abortions from actually enforcing that rule. Viability is a difficult regulatory line to enforce. It's uncertain. It's subject to debate. The abortions that are near or beyond the point of viability take place in private facilities so that the information relevant to law enforcement is out of the medical mainstream, and that some public health officials, perhaps many of them, I don't know, are disinclined to closely monitor abortion providers. What could be done to overcome those particular barriers? I suggest a couple of things. Teresa talked about these laws that different states have been enacting forbidding abortion, or at least elective abortions, after 20 weeks. It strikes me that an alternative explanation for the value of that is it would help the state with its compelling state interest in protecting viable fetuses. The 20-week line is shortly before viability. It would give the state a little margin of error and make it would be an easier line to enforce than viability itself. Secondly, the problems of lack of information and inadequate state oversight could be addressed by requiring at least some second trimester abortions to be performed in hospital settings. Hospitals are more closely monitored than abortion clinics. It would be more difficult for medical personnel to conceal evidence that abortions were being performed on viable fetuses. One additional point, and I take Caroline's point about being careful about science, right? And I'm not a scientist, and so I deliberately went to the Guttmacher Institute's website to get my information here. But they talk about how the risk of death associated with abortion increases with the length of pregnancy. Early in pregnancy, they say, 1 death for every 1,000,000 abortions. When you get to 16 to 20 weeks, it's 1 death per 29,000 abortions. By the time you get to 21 weeks or more, 1 death per 11,000 abortions. They're relying upon a study by a group of researchers named Bartlett and et al. And they gathered data and put together a model. According to their model, there's a 38% increase in the risk of death for each additional week of gestation. So it seems to me a hospitalization requirement has medical justification as well as helping the state to enforce its compelling state interest in preventing post-viability abortions.
To the small number of complications and emergency situations that we see in the provision of abortion care. So while yes, that is a tragic instance that can be cited, across the board application of these kinds of physical plant standards, we would argue, it's not necessary for the maintenance of patient safety, because on the whole, the provision of abortion care is incredibly safe and is not, not often resulting in stories such as that instance. And I think, what we have not considered is a question that you are specifically asking about hallway widths as separate from the totality of the physical plant standards that have been applied. In Virginia, it's our interest, of course, but you can look at other TRAP statutes and regulations across the state. I have not seen literature on. If folks have, please inform me. I'd be very interested to know on what the impact would be if we simply had a physical plant standard that related only to hallway widths and did not include the other physical plant standards that all combined together are we argue a attempt and deliberate intent to shut down those clinics by imposing all of those facility requirements at once together.
So I just want to.
Yeah, let's ask others to comment. Yeah.
So it seems to me that so many women have to resort to so difficult and expensive to access abortion otherwise, and one of the main reasons why abortion has become so difficult and expensive is all these laws that claiming they're acting in the women's best interest, but are really just making abortion more difficult and expensive.
I guess every piece of litigation that I've been involved in, from the Texas abortion regulations, where we had a Kermit Gosnell type provider, so that actually other abortion providers were not all that angry about what was happening because they didn't know how to get rid of him either. To current cases, the Klein case, the Truitt case, the claim is always that all these abortion clinics are going to close down. And if you have extended experience in one particular state where one clinic is constantly the plaintiff, in year 12, with the fourth lawsuit where they claim that this regulation is going to put them out of business, you become a little skeptical about that. And so, while I think it's interesting that the Norfolk clinic has closed, I'd be really interested in an economic analysis of where they were financially even before these came into effect. Because we don't really worry about other areas where we think regulation is appropriate and necessary, whether or not it drives bad actors out of the market. We actually celebrate it. If restaurants are operating in substandard policies for health and they have to close down because there are cockroaches in the kitchen, you know, most of us are glad that we're not eating there anymore.
Of course, the key phrase is appropriate and necessary, and when doctors say they are neither, then you have to wonder whether they are.
Depending on whether they have an interest.
And let me see if Professor Beck would like to make.
Let me ask one question. What would you think, Kathy, about a rule that said a state can apply to an abortion clinic any rule that it is willing to apply to other outpatient facilities that present comparable health risks? So you can, if you apply the same rule to dental surgery or LASIK surgery or whatever, you can also apply it to the abortion clinic.
I think with the caveat that the medical community agrees that that is a medically appropriate rule for the provision of abortion care. So it is difficult, I think, when we talk about the singling out of abortion providers and comparison to comparable procedures. Of course, one of our main goals is we don't want to see that singling out occur. We think it's for ideological and political reasons rather than medical reasons. So the application, of treating folks the same, I think, would be a great victory, but only in the instances where it is indeed true that that rule applied to abortion facilities, in addition to the dentist doing surgery, makes sense for both the dentist and the abortion provider. Makes medical sense.
We have a slew of questions, so we'll start with you.
I don't remember what it was because I got distracted by this point. So for me, you had, I thought the premise of your talk was that it's difficult for states to enforce the viability line, and I understand your argument there in terms of viability being something that is left to the discretion of the physician. But I don't understand the link to Dr. Gosnell's clinic, because as you pointed out, there were so many reasons why the state could have and should have shut his clinic down, and I don't understand the problems there to have been that he was determining viability wrongly. I mean, obviously
Right.
he was doing that too, but even that could have been a problem.
Yeah, I don't think, saying that the line is at 20 weeks would have stopped Gosnell, because Gosnell's whole, market advantage was, I'll do the abortions nobody else will do, right? I do think that is one problem, the kind of the murkiness of the viability line, and that there are other problems that I think Gosnell illustrates, which is the privacy of the abortion clinics, and then sometimes unwillingness of state officials to closely monitor.
Anybody else before I open up for one question? Okay. And I think we can monitor. Yeah, I
frustrating and exhausting about debating abortion is, the sense of disingenuousness about certain arguments and hard to parse out what are real concerns, what are just ways to block access. And you see that around the trap laws, right? That, one side thinks the other side is making disingenuous arguments, right? And you have the scientific community saying a lot of these things are unnecessary. The sole purpose is to increase the cost, shut down clinics, make abortion inaccessible. And when it becomes this war, right, and it is also hard for the pro-choice community, which wants to protect women's health, to even say, yes, what regulations we need to get rid of the gosnells, along with increasing access to abortion. My understanding is that Maryland recently actually accomplished something like this. So in the spirit of balance and coming together, that they were actually able to get both sides to the table, enact new regulations that actually serve the purpose of protecting women's health, that were tied to evidence-based reasons for certain kinds of health and safety regulations, but also not designed to block access. I'm wondering if you're familiar with that, if you know what kinds of things they did and what kinds of things they rejected. Because my understanding was there was a sense from the pro-choice community and the pro-life community that these were actually good regulations.
That's a great question, and I'm actually not as familiar with the Maryland regulations as I should be. I do know that in contrast to Virginia, they are not applying these, onerous physical plant standards. And I think what's especially problematic about Virginia, as I mentioned, is that they're new hospital construction standards. So we certainly don't see that in Maryland. I don't know what process they underwent to bring folks to the table that resulted in regulations that both sides, so to speak, could agree on. But what I think is disheartening, especially about what we see here in Virginia, is that I believe that our Department of Health tried to engage in that similar kind of process when they brought that medical committee to the table. These were folks who are, as I said, personally pro-life and pro-choice and feel very strongly about that ideology in their personal lives, but then wanted to approach this issue as they do in their practices as physicians and what is medically appropriate. And I think it's a real shame that the politics and the divisiveness of this issue, I think it interrupted what was a similar goal by our Department of Health here.
Any of the other panelists want to comment on that? Okay, so I think we have Professor Brown.
Let me try to connect three dots here if I can. Randy, if I understood him correctly, is, as a bottom line, proposing a 20-week hospitalization requirement, which I, at least, extremely unrepresentative of extreme pro-choicers, would be happy to endorse. Teresa touched upon Hornby Isaacson, 20-week ban, which in the Ninth Circuit went into a panel that included one of the most conservative federal appellate judges alive, Andy Kleinfeld, didn't even get Kleinfeld's vote. So I will be very surprised if they grant Horn versus Isaacson. But we have the Klein case out of Oklahoma that they did, and then we've got Planned Parenthood v. Abbott out of the Western District of Texas that's now on the emergency application to vacate stay that was filed Monday morning. But we're going to get an inter-circuit conflict over these statutes requiring providers to have hospital admitting privileges within 30 miles, which is the question in the Texas case. Now, we've got 4 federal district court rulings, which have all found that a 30-mile admitting privilege requirement fails rational basis analysis. Same thing with the Klein case, which is preventing medication abortions from extending to 63 days rather than 49 days per the off-label usage FDA issue. Now, I'm saying this mainly to the folks on the other side. To have a common ground conversation, we need to talk about things like what Randy is saying. Should there be a 20-week hospitalization
guess I'm skeptical of the idea that there's no rational basis for the admitting. I mean, it strikes me that you have to be applying rational basis with a bite at that point, because if nothing else, admitting privileges maybe is a credential that shows the qualifications of the doctor, or some. If you're creative enough, you can come up with a rational basis for it, I'm sure. But I don't know the medical literature on or what's being argued as the reasons for those requirements, so I can't really comment intelligently.
Any other reactions?
Just 15 years ago, the National Abortion Federation had the same requirement as in their clinical policies. They removed it after it became the subject of litigation. But that suggests to me that if NAF, when Warren Hearn was at the helm, thought it was reasonable, that the evidence is there. We just haven't presented it appropriately.
I had a question, Caroline, about that compelled speech doctrine and the claims by physicians in the abortion context. So, as I think you pointed out, Casey did include that claim. The doctor did make a claim in Casey that they were being forced to speak that violated their First Amendment rights. And I think you suggest that strict scrutiny applies in that case. And please correct me if I'm wrong. But yet, the court in Casey doesn't mention compelling interest, doesn't mention whether it's measured morally tailored, doesn't use either of the markers of strict scrutiny. So it's hard for me to, I'm wondering how you deal with that. And the second related point is that the court, when it does speak about the compelled speech issue, it mentions Willie v. Maynard, one of the quintessential compelled speech cases, but it qualifies it and says that yes, the physician's free speech rights are implicated, but in the context of medical regulation, which is subject to reasonable licensing regulation by the state. And the court, in doing that, when it makes that statement, references Whalen v. Roe. And in Whalen v. Roe, the court talks about the fact that the patient's, or that the physician's rights are derivative of the patient's. Very similar to what the court says in Casey as well. So the point is that if the patient's rights are not violated, then neither are the doctor's rights violated. Very similar statements we see in Casey as well. So how do you deal with those problems? I think those problems in interpreting cases to require strict scrutiny.
Right. So there are two levels of answering this. One is, I have to say, Casey got it wrong. And when you're dealing with doctor speech and you're requiring them to say something they don't want to, you have a First Amendment problem. But assuming Casey is correct, the point in Casey was that if what the doctor is saying is part of medical practice, then maybe it's not subject to strict scrutiny. Right? The information has to be relevant, truthful, and non-misleading. And the disclosure in Casey was about the gestational age of the fetus. And that was considered perhaps relevant to informed consent because the type of procedure used depended on the age of the fetus. That is not the kind of information that is required in the kinds of cases we're seeing now. Right? So the statement that the woman is about to terminate the life of a whole, separate, unique, living human being is not quite the same. Right? And the Eighth Circuit itself acknowledged that standing alone, this does kind of sound like an ideological statement and taking a position on morality and abortion. And the way they got around it was by arguing, well, this statute defines human being as a member of the species Homo sapiens, right? And so they allowed statutory definition to transform a statement that most people would understand as ideological into a factual statement. But then if you think about what informed consent is and is not supposed to be, informed consent does not require telling women things that are rather obvious, right? You're not supposed to tell people obvious things in informed consent. There's no need for it. And the point of that statement would be to tell women that the fetus they're carrying is a human fetus as opposed to, say, a panda or dolphin fetus, right? That's really not relevant information, right? That's sort of obvious. So their attempt to change the ideological statement into a factual statement is sort of unpersuasive. And I think we can all understand what's really going on, right? It really is to try and persuade them. So my point is there's a very big difference between telling a woman this is the age of your developing fetus and telling a woman you are about to commit murder. Right? And when you're dealing with an ideological statement, right, even if, say, you're dealing with commercial speech, you cannot require someone to articulate the government's ideological message. So if you take the commercial speech, like tobacco companies, and their advertisements, right, you're required to show factual images of what happens to you when you smoke, like a picture of the diseased lung. And in that, and the advertisers, tobacco companies brought compelled speech claims, and they were struck down as violating the free speech clause because they were considered too ideological because the government was trying to convince people not to smoke. So you have sort of very parallel situations, and on the one hand, the government very clearly applies free speech jurisprudence, and in the abortion case, it simply does not. And I would have to completely disagree with you to say that the doctor's rights don't have rights that the women don't have. These are separate issues. Free speech clause is a separate clause that provides separate protections. You can't pass laws that violate the free speech clause.
Well, with that, I feel that somebody surely wants to respond. I am, however, keeping you from coffee, so any advice from Spidey or Laura whether they would like this to go a couple more minutes?
We can go maybe to 10:35 and sort of shorten the
Okay.
break for 10 minutes.
I'm all for the response.
Okay.
Thank you.
In fact, there is a large body of law regarding professional speech, independent, and every person in this room that holds a law license knows that the state can require us to make statements. The state can require us to stand silent when we would like to talk about particular judges or talk about particular cases or talk about any number of things. And so the idea that physicians should be immune from regulation in the same way that every other profession has consistently been subjected is not an accurate depiction of the jurisprudence.
And that is not what I said. I
And?
said compelling them to speak in the practice of medicine may be subject to lower level of scrutiny. Compelling them to say ideological messages unrelated to the professional ethical practice of medicine is not.
And may I finish? Thank you. And in addition to that fact, the self-reports about ultrasound, where they are peer-reviewed, published by people in the abortion industry, indicate that women often have been told or would like affirmed that it is a human being. So, and I quote from the South African Medical Journal, it allowed me to say goodbye. It allowed me to see what was occurring. And so to equate physicians to cigarette manufacturers is, to me, a very odd analogy.
Now, I know that Professor Beck had a comment. I don't know if you do, but let me start with him.
I just had a question, a clarification. Under the South Dakota statute, did the doctor have to say the words? They couldn't just hand a sheet of paper. Okay. Could they say, here's what the state requires me to tell you, but I don't agree?
It's not clear.
I think the trial court was very clear on that.
It's not